Hey YouTube. Hi, nice to see you. Hope you're doing well. Happy almost Thanksgiving. I wanted to come and give you guys a video for the week. I'm going to do a reaction video. This is a sovereign citizen reaction. And again, for context sake, I'm a criminal defense attorney. I've been a criminal defense attorney for 10 years. Okay, so this video is called Sovereign Citizen Appears in Court for Threatening Judge. And also disclaimer, I have never seen this video before. I try to make sure that the video is like somewhat short, and then I just react to it.
I made it very clear in my letter to Judge Seal that I intended no harm for anyone, but I will hold him accountable. He is in violation and not in compliance with 46-13-104, and I as a means of
46-13-104. Okay. Is this a bond review?
civil disobedience, I refuse to pay the fees on that disorderly conduct because he refused to present to the court an answer to a pretrial motion, which he is required to do by the legislature. I've asked.
I've read that in your filing, sir, and I understand that. But on this hearing, what will happen is that everything that we're talking about in reference to this case will be handled up into the district court. This is just a cursory hearing. It's your initial appearance.
Oh, okay. So this guy it looks like he has a disorderly conduct charge. He appears to be a sovereign citizen. He's filed some pretrial motions, but this is just an initial appearance. So an initial appearance, depending on what court your case is in, if it's your circuit court, your district court, your appellate court, but the initial appearance is usually just where the judge gives you a formal reading of the charges, advises you of your right to an attorney, and ascertains what you want to do as far as representation is concerned. Do you want to hire an attorney? Do you want the services of a public defender or court-appointed attorney, depending on how that state does it? They also ascertain at the initial appearance, like what your next court date will be. And sometimes they'll consider the conditions of your current bond. So they might look at the case and say, oh, it looks like this guy might need a reduction in the bond or not. So that's what initial appearance is. It is not about the facts of the case. It is not about guilt or innocence. There are no motions issues that are advocated or argued at an initial appearance. So he's trying to argue his motion based on, I guess him not complying with paying some type of fine or something like that. But that's not heard at initial appearance. It's a precursory hearing just to determine kind of like to determine the course of the case, right? And to make sure that you understand what your charges are and to let you know that you have the right to an attorney.
Well, it's not your initial appearance. It's just an arraignment and let you know what the charges are against you. And then you'll actually have your formal hearing in the district court where this matter will be heard. I'm a court in limited jurisdiction, so I'm limited on what I can do.
Mm-hmm. So he says that it wasn't an initial appearance, it was an arraignment, but initial appearance and arraignment have just about the same function. I'm not sure what state this is in. But yes, the judge at your initial appearance or at your arraignment he said court of limited jurisdiction. They're limited in what they can do. They can only do the things that I already told you guys about. They can't do anything more. They can't determine guilt or innocence, for example.
Your Honor, I would like to appeal to the court regarding the amount of bond. I've been a longtime member of this community, and I'm actually the head usher for the Bozeman Symphony. Have been for several years. Yesterday, I was the man who called the Belgrade Police Department, not once, not twice, but 3 times regarding a 5-year-old little girl who's walking southbound on Jackrabbit Lane after school and looking around because apparently she probably missed her bus.
Okay, I see what he's trying to say. Pro se defendant representing himself, you might be able to finesse that a little bit better if you had attorney representation. But he's asking for the court to hear his bond. I'm not sure in that state if they're allowed to at the arraignment. But I know for us, the judge can consider the bond at any time in our state. So let me see what this judge does.
I'm the guy who called the police. I'm the guy who called the Belgrade Schools Transportation Department to let them know which bus it was that we ended up getting her on. I'm not a person who's looking for trouble. I'm not a person who is trying to cause trouble. My only goal is to hold Carl Paul Seal accountable for failing to comply with the law. He is a judge and he's required, and I might add that
Okay, so I don't know what he means by holding that judge accountable, but that's not relevant to the conditions of bond. When you want the judge to consider your bond, the thing that you want to talk about is, are you a danger to the community, which I think he was trying to say that he's not. Are you a flight risk? Those are the two overriding. There's other little smaller factors in there that help you determine those two major factors, but those are the two major factors. Are you a flight risk? Are you a danger to the community?
One of the other municipal judges here in Bozeman,
Montana.
Judge
Bozeman,
Colin
Montana.
Harrington, assured me in another hearing that Judge Carl Steele would present that document to the court, and he never has.
Okay.
I appealed it to the Montana Supreme Court. The Montana Supreme Court ignored it because he and Justice Jim Rice are old friends.
See, so the way that he's actually presenting himself right now, and he opened the door. He asked the judge to consider his bond. The judge doesn't have to consider his bond. I don't know what this judge is going to do. I don't know if he's just going to ignore what he's saying, which would be to this man's benefit, or if he actually is going to consider it. But by you saying you want to hold this judge accountable, that could kind of be read the wrong way. And then you're talking about a conspiracy between that judge and the Supreme Court of Montana. That is going to make it seem like maybe you're potentially a danger because you're delusional, right? It's unlikely that this judge, without some type of further evidence, is going to believe that there's some type of danger or some type of conspiracy between the judge and the Supreme Court. The Supreme Court of Montana likely dismissed this case because it didn't have merit, or decided not to take it up because it didn't have merit. And so when you start going off subject and you're unable to comport yourself with the decorum of the courtroom or answer the judge's questions, you may give the judge an indication that you are mentally unsound. And if you seem like you're mentally unsound, the judge can assess maybe this person is dangerous, or maybe they're incompetent and don't understand the proceedings that are before them. So I'm going to hold them in order for them to get an evaluation, or I'm going to revoke the terms of their bond because I don't trust that this person won't pose a further danger or be a flight risk because they can't follow directions or listen because they have to interrupt the court so much. So it's not only what he's saying, it is what he's saying, but it's also how he's saying it that I think is walking him into dangerous territory. But we'll see.
This is a political witch hunt is what it is, Judge.
As soon as the judge starts talking, you should stop talking. They should never have to interrupt you, and you should never interrupt them.
This is not, I have made no physical threats. I am no physical threat. I want to hold Judge Carl Steele accountable. However, wherever this kicking his door business comes from, Judge, that is news to me.
Kicking his door?
I've never spoken to anyone like that.
And I appreciate that, sir. And these are just alleged offenses, and what will happen is the case.
So at the time of the initial appearance or arraignment, the case has not been proven yet. It has not gone to trial. And he can argue all of these things to the trial judge or the jury, however he determines that he wants to proceed. This is not the appropriate time to bring these things up. It's literally supposed to be a speedy hearing where you're told about what your charges are, your right to an attorney, your court date is set, and then you can ask the judge to consider bond.
While it goes upstairs, all that will be ferreted out, but I can't do that here. It's what I'm trying to tell you.
No.
But I understand, and I'm sure the parents of, hold on.
Oh,
I'm
this
sure
judge
the
has the
parents
patience
that
of
were
Job.
very appreciative, as the community in Belgrade probably was.
Yeah.
Okay, so
It's
what
so
I'm saying
kind.
is that I understand the $50,000. People understand. What is that going to do to ensure the safety of the community and those types of things?
Okay, so his bond is currently set at $50,000. Obviously, I don't know why I was saying disorderly conduct. Right there, it says in the title, threatening a judge, right? But he's accused of threatening a judge, and now he's talking about how he wants to hold this judge accountable. What it sounds like he's saying is that he did it, but the reason he was doing it was to hold the judge accountable. You don't want to sound like that. I don't know. I just feel like he's digging himself a hole at this point.
But what is to do is to ensure that everybody abides by the conditions that are set.
Right.
And a monetary figure always is something in our minds that we think about.
That's right.
Now, what you're talking about in reference to getting a hearing, you will have that in the district court. Well, bond will be readdressed there.
Okay. So the judge set the bond at $50,000. He's explaining to him the purpose of the $50,000 is that it tells you that if you're able to make that $50,000 and you're out on the street, you're less likely. The hope is that you're less likely to go and bother this judge or commit any other offenses because that $50,000 is sitting in the back of your head. Like, that's money that you'll never get back if you don't show up for court and behave yourself. And the judge is saying that you can once you get your case to district court, the next judge can determine your bond status.
No, it won't be this afternoon. I'm not sure. Miss Kramer and the public defender's office will assign you an attorney. They'll file the appropriate paperwork after.
He's not going to want a public defender.
Well, Your Honor, I'm sure you must have read the letter that I delivered to Carl Seal.
I only have the.
So if you guys stay tuned to the end, you will see why that statement he just made was completely disastrous to his entire case and why people should not represent themselves in court and shouldn't talk about their facts of their case at their arraignments or the bond review.
Which would be the same thing that you would have received.
Okay,
With the warrant. That's what I'm saying. Like I'm saying,
Don't talk about the facts of your case.
We're going to go the way that we are. All the information will come out upstairs, but I have limited information. I only have what's in the complaint because this is just a preliminary process to get your case into the right court.
Yeah.
Okay, Your Honor, but I do want to object to something by the state's attorney today.
Yes.
He brought up the document that I submitted to the Montana Supreme Court, and he didn't read the full part of the document. It's taken 2 years.
This is not
ago,
relevant.
and he approved my concealed weapons permit at the time, which was revoked from me by Sheriff Gookin after Madison Mattioli.
He sounds like he is really all over the place. And to be honest, he sounds mentally ill. You know, he doesn't sound like this is not the purpose of the arraignment, is not to get to guilt or innocence. You say you maintain your innocence, you didn't threaten anyone, you would like bond to be said, thank you for my court date, and move on. But this is like, all this other stuff he's doing it doesn't help anything. This judge doesn't have the authority to hear these issues.
With that document, a full month after I filed a complaint on her for lying to the tribunal.
Oh my God, he seems difficult.
After I filed that complaint to the Office of Disciplinary Counsel.
Okay.
Judge, this is a political witch hunt, and I'm being. Here's the last request that I will have of you, Judge, because I've already.
He's not even requesting anything.
To the sheriff's deputies or the jailers here at the Yellen Law and Justice Center. I have made the commitment. In fact, I even said the same thing to several people, several civilians, including Gene Hodges of the Bozeman Opera, that I have, if I'm going to be.
This judge is being really nice because I know several judges where I practice that would have cut him off already and passed on to the next case. They literally would have just had the sheriff's deputies remove him and gone on to the next case.
In jail on this because I'm trying to hold Carl Seal accountable to do his job as the legislature has required him to do.
Well, the Supreme Court disagrees with you on that.
Myself, while in jail, to be on a hunger strike, and in 2 weeks I will be in the hospital, a faint, gaunt skeleton of a human being for the world to see, because this is a political witch hunt.
So now he is threatening to go on a hunger strike in response to this judge not following some type of rule he thinks he should follow. But the Supreme Court has already disagreed with him, and now he's accused of threatening that said judge. And now he's saying he's going to go on a hunger strike. Then none of this is relevant to an arraignment. You know, like he is wasting a lot of energy doing something that is going to get him nowhere. This judge does not have the authority to hear these issues. And also, hunger strikes are often ineffective. I have some experience with people going on them in incarceration. Hunger strikes are often not effective because then the jail can just get a court order to force feed you.
Because Carl Seal sought to find that he has personal knowledge that I did not commit the crime of disorderly conduct on November 20th.
I get it. So, okay. So he was charged with disorderly conduct, which is such a minor charge, and usually people only get fines or a little bit of jail time for. And he turned it into now he's charged with threatening the judge. And the judge found him guilty. He refused to pay the fine associated with his sentence. And he appealed, right? And in one of these writings, he allegedly threatened the judge. It's so unnecessary that the case got here.
2013, and he went out of his way to make sure a 21-year veteran police officer witness could not testify. I am not guilty to the mood.
It's not relevant. It's not relevant.
2 weeks because I am refusing food from this day forward.
Okay.
And I'm asking the people of Montana to contact those.
So then what judge then is going to say, oh, I'm going to reduce your bond from $50,000 because you're threatening to do something that is so disproportionate to the harm that you're alleging. You're threatening to hurt yourself in order to protest what? You're going to get your day in court. You know, they're not going to drop the case at the arraignment. So it's not like he is receiving some type of negative treatment at the jail or something like that. Either post the bond or don't. But threatening to starve yourself for 2 weeks, it shows me that you have something else going on with you. And I would think you maybe not a danger to the community. Maybe you're a danger to yourself. And you're certainly accused with doing something that's dangerous, which is threatening a public official.
Municipal court, to contact Marty Lambert's office, to contact Sheriff Gutkin, and demand answers for government accountability.
Thank you. And like I said,
Thank you.
don't disrupt the court back there. All right? Clapping in the courtroom is not okay. Okay, I've heard you now, Mr. King.
Now he's got people
And
clapping
I
for
appreciate
him.
you. I've heard you. Okay.
He's listened to you. He's been very nice.
More information, Your Honor. So how
But
does
that
But he hasn't asked. The interesting thing is that other than asking for the judge to review the bond and the judge making his ruling on that, he hasn't asked the judge to particularly do anything. He's just threatened to do a hunger strike, but he hasn't asked for he hasn't made an oral motion that the judge can even rule on. See what I'm saying? Like, he's complaining a lot and yelling a lot and saying he's going to starve himself, but he hasn't actually said anything that the judge can actually do anything with. Very interesting.
that'll be the
the
next.
evidence before you change your opinion?
No.
Change his opinion about what? The bond?
You'll be
No.
discuss these down. We'll post in your bond, sir. Thank you.
Thank you.
Thank you, Your Honor. And
I should
thank
look-
you to the people of Montana for helping me and
Polly
bring
Richards.
out this injustice.
He is disrupting the courtroom. Okay, that was very interesting. That is an interesting individual. Who is he? I wonder if he's okay. Okay, I found, so someone pinned a news article about it. Okay, a Belgrade man emphatically pleaded not guilty Wednesday to threatening a Bozeman Municipal Court judge. James William King, 45, appeared before Gallatin County District Court Judge John Brown, who has the patience of Job, and entered his plea to a felony charge of threats and improper influence in official and political matters. When Brown asked King his plea, King responded categorically not guilty. According to charging documents, following a trial in September of 2014, King was convicted in Bozeman Municipal Court of misdemeanor disorderly conduct. Judge Carl Seal, who oversaw the case, fined King $235 plus court fees. So he got off pretty easy. King appealed to the Gallatin County District Court and then eventually, okay, so the district court is the higher court for them. And then eventually the Montana Supreme Court. In a filing with the Montana Supreme Court in August, King wrote that he was at the end of his rope and that he positively did not commit the crime in question. Barring the civil remedy, the only remaining options to my knowledge is indeed the last final defense of a free person, people against tyranny, the Second Amendment. Oh. King wrote, King's conviction was eventually upheld by the state's high court. A confidential informant had several recorded conversations with King between December and March. During one conversation, King said he had a list of the names and addresses of all law enforcement officers in the Bozeman Police Department and the Gallatin County Sheriff's Office. Ooh. And also claimed to know the names of officer spouses. King said that if there was no other choice, he would make an armed citizen arrest on a judge. I may lose my life, but I'm going to make it expensive. At least the judge and me are going to be dead because the judge is going to be my first shot if you open fire. In another conversation, King again so $50,000 bond for saying these things is actually not too bad. I have people held on no bond that didn't say anything like this or do anything like this. On March 16th, the day before King's fines and fees had to be paid in full, King appeared in Bozeman Municipal Court and informed Seal that he wouldn't be paying the fine. Seal then ordered that King had until the end of the next day to pay or that he would have to serve 2 days in jail. King did not appear in court again. On March 19th, Seal was at home with his wife when she saw someone walking up to their door. A letter was later slipped under their door and the person walked away. Oh my God. The letter was from King, who accused Seal of lies, cover-up, and corruption in his case. King wrote that the city and the state risked substantial liability due to Seal's conduct. King went on to write that he wouldn't be in court and that he expected Seal to defer his case. King wrote that if Seal or any other judge took action against him, that you can anticipate the courtesy to be reciprocated. King signed the letter and also emailed a copy to various public officials later that night. Oh my God. Oh. In a motion King filed Tuesday, he again emphasized his innocence and requested that the charge be dropped. This felony allegation is a fabrication. King accused the sheriff's office of tampering with the informant. This is nothing but a political witch hunt stemming from my demand for an accountable judiciary. Once the facts can be told, Mr. King is certain he will be exonerated and released without any further delay. Oh, he wrote it about himself, but in the third person. Brown ordered that King have a $50,000 bail be continued, and that if he posted, he must wear a GPS monitor, and that he not come within 300 feet of Seal. You really went to this man's house? That's crazy. And if you guys notice in the hearing, he actually admitted to it, because he said, my letter was taken out of context. Did you read the letter? Did you read the letter? The letter is the one that you dropped off at his house. You should never, ever go to a judge's house. It's uninvited, or, obviously. But you should never go to a judge's house and, try to leave them correspondence or contact their family or anything like that. Never take any correspondence with the judge outside of the courtroom or in their official capacity. It's completely inappropriate, but also can land you in serious criminal jeopardy. Okay, so this is the outcome according to AP News. A man convicted of threatening a Bozeman municipal court judge, so he was found guilty, over fines owed at a years-old disorderly conduct case has been sentenced to 10 years in prison. That's, wow, 10 years in prison. The Bozeman Daily Chronicle reports 46-year-old James King was sentenced Friday and will not be eligible for parole for the first 5 years of his term. So he turned a $235 fine into 10 years in prison. Don't let this be you. I keep saying that it could all be so simple. People will take their, sometimes you get into criminal trouble because it's the worst decision you've ever made, or you got really, really unlucky. And people take that and turn it into a snowball of ruining their own lives. This man got 10 years in prison. Oh my goodness. I'm a softie, right? My heart is really soft. It's really easy for me to get upset for people. Even though this guy was seriously, dangerous, mentally ill, unable to conform himself to the mandates of society, I still feel really sorry for him, because he took what was, like I said, just a disorderly conduct and just escalated it to the point where now he's in prison. That's really, really sad. Anyway, guys, that's my reaction to this man appearing in court for threatening a judge. That's the allegations, and that's what happened to him. And if his behavior at the arraignment is any indication of how he would act in real life, then I think they probably had a really strong case on him. They even had him recorded. So let me know what you guys think in the comment section below, and I'll talk to you later. Bye.